Bail hearing, principal seat case matter.
Mr. Parasar, do you have the
Yes,
Is there
CD available. CD available, my lord.
Now it will not be possible for us to produce the CD or do anything from here.
Yes,
We'll
my
have it
lord.
on Tuesday or Wednesday.
Otherwise, my lord, one thing is that, my lord, earlier it was rejected by your lordship. There are three petitioners, Sanwar, Manwar and Anwar. They are all brothers
Ah,
and in the intermediate case, my lord, NDPS intermediate. Subsequently, Anwar was arrested in another case, which is not Gauhati PS case number 09/26. It was of commercial quantity. Now his statement also available, my lord. All brothers are doing this, my
and
lord.
in that case, two of them are before us, na?
Yes,
To
Lordship.
now to earlier it was rejected AB 2861 of 25. It was rejected by your lordship on 21 January.
We
26.
have seen that. We'll do it this way, Monday or Tuesday.
My lord.
Tuesday.
Tuesday.
Tuesday, okay.
Obliged, Lordship.
Let's this matter again on Tuesday at the principal seat. Thank you.
Obliged.
For admission, item number 1.
If I may please, my lord, sir. I beg
Yes.
to mention from the part 2 list, my lord. Item 14, my lord, this is a jail appeal. It's a consensus prayer. I am for the respondent number 2. If this can come up after a week, my lord. I've taken consent from all the parties.
At the prayer of the learned council, appearing for the
Respondent number 2.
respondent number 2, comma, who states that the consent of the counsel for the appellant has been obtained, comma. This is matter after a week.
My lord. Oblige.
May it please your lordship, may I seek indulgence in mentioning item number 3 of part 2. The leading counsel is from outstation and we could not appear today.
Okay.
So if the matter be kindly listed after 3 weeks, your lordship.
He could not come today, so we'll go back by 3 weeks.
Yes, your lordship.
At the request of the learned counsel, appearing for the appellant, comma, who is stated to be outstation counsel. List this matter again after 3 weeks.
Deeply obliged.
Yes, this is item
Item number 1, please.
1.
Your Lordship, as per the information that I have received from the district collector, they are in the process of disbursing the compensation at this stage, Your Lordship.
Most of them have already received. Few like 3-4 persons were left.
Okay. We'll have it after 2 weeks,
Yes,
by which
Your
time the
Lordship.
complete compliance should be
Yes.
there.
Hopefully.
Learned counsel for the Miss Mary L. Kiante, counsel appearing for respondent number
It's 15, Your Lordship.
15 has submitted that the order of which contempt has been alleged is already partially complied with payment being made to most of the petitioners. Full stop. The learned counsel appearing for the petitioners, Mr. Victor L. Ralte, has submitted that a few petitioners remain to be paid the compensation. To enable a report on full compliance of the orders of this court, comma, list this matter again after 2 weeks.
Deeply obliged. Club में काम करते हैं.
Item number 2.
Madam so and so appears for the respondent. You are appearing for respondent number?
Number.
I am for respondent number 8 and 11.
Okay.
Item number 2.
We'll just say after 2 weeks it will come up someday. Yes. What about item number 2?
Your Lordship, item number 2 and 3, similar order
Same.
may be passed.
1, 2, and 3, huh? But it will be separate orders. All 3 separate.
Item number 4.
May please the lordship, my lord, on the last court's occasion, my lord, I was instructed to make amendment to the course title, my lord, so I have prepared the same. And since the original copies in the before the court, my lord. I cannot take steps, so I'll take during the course of the day, my lord.
No, the original copy will always be with the court.
Exactly,
You have
my
to
lord.
deposit
So I
it to
have
the
to
registry,
replace,
sir.
my lord. Yes,
You have to give it to the registry. They'll do what? You are not supposed to open the file.
definitely, my lord. And with regard to the service, my lord, it's all completed with regard to number 2. And with regard to number 3 is represented by my learned friend, my lord.
All parties are represented.
Yes.
Are all
Your
the
Lordship.
parties represented?
My learned friend is for the newly pleaded respondent number 1. And my learned madam, Miss, she's representing respondent number 3.
Who represents 1?
One, I represented one.
Present.
Yes.
He represents 3. Who is 2?
Who is the owner of the vehicle?
My lord, as far as my knowledge is concerned, 2 is not represented yet. However, the ID card was received
Show
Eddie
me the
return on-
correspondence file.
to respondent number 2. So it's not represented as of now, my lord. It was received on 24/2/2026 at the return. Respondent number 2 is the owner of the vehicle, accident vehicle.
Ah.
It's not very much, my lord, needed in the appeal, I believe.
And what if you try to push the entire liability towards the owner and the driver? If you don't pay, someone pays.
My lord, the appeal is for the setting aside the whole award. Not
Suppose we come to a conclusion
exactly, my lord, I understand.
that it is the driver who's responsible or the owner who's responsible to pay. Then
My lord,
what is his name? Vanlal Rota.
R. Vanlal Ruata, son of R. Daukunga, College Venga is on, my lord.
You'll have to take fresh steps.
Yeah.
All right, my lord.
Heard Mr. So-and-so, learned counsel, appearing for the appellant.
My lord.
The learned counsel prays for an opportunity to submit the amended cost title to the registry in accordance with the order dated 3/8/2026. Full stop. Mr. So-and-so appears for the respondent number 1, while Ms. So-and-so appears for the respondent number 3. Next para. In the office note dated 25/2/2026, it has been recorded that the AD card in respect of respondent number 2 has been received on 24/2/2026 and was kept in the correspondence file. On perusing the same, it is seen that the AD card has been signed and has not been signed by the addressee, but has been signed by some other person, full stop. In view of the above, the appellant shall take fresh steps for service of notice on the respondent number 2.
In the meantime, Your Lordship, we haven't received the appeal memo. Sir.
You have not received the
Yes. Appeal memo.
payment,
Appeal memo. Appeal memo.
or you have not received respondent number 2, full stop. The learned counsel appearing for the respondent number 1 has submitted. You have also not received.
Not yet. Because I was newly impleaded.
The learned counsel for the appellant shall supply copies of the appeal to the counsel appearing for the respondent number 1 and 3 in the meantime. List again on 8th of September with service report.
Obliged, my lord.
Obliged.
Item number 5.
For respondent number 1, 2, and 8. We already compliance with the court order as per my instruction, my lord. We have deposited 3 crore point something to the DC. My lord, if I am permitted to place my instruction,
Where is the order of the court?
Page number 45. Page number 45.
disbursed.
Para 18. This number 45, para 18.
Uh-huh. No, it is to be refunded.
So
Says
for,
the amount
my lord,
demanded.
so far as this, there are three directions given by the learned single bench.
Ah,
So far as 18.1 is concerned, there was an appeal. The division bench had to interfere with this order, number one, and there's a SLP pending at the moment.
okay.
And so far as number two is concerned, regarding determination of the interest payable, my lord, here we are concerned with regarding this, which my learned friend has recently submitted, that they have made the sanction, which is not yet disbursed.
Yes, who appears for the deputy district commissioner?
Your Lordship, I am appearing for the DC Siaha, and as per the information that I have received, as recent as the end of July, they have received the deposit.
Okay,
So disbursement at this stage is not yet
complete.
no, it's not yet initiated.
So,
It will be
how much time would you require?
At least 3 weeks' time, Your Lordship.
Have you established the land acquisition,
Yes, my lord, this,
rehabilitation and
this they
resettlement
have
authority?
established,
Huh?
already done.
Done, okay. Heard Mr. And the council appearing for the petitioner. Is it recorded in any other earlier order? Well, the council has submitted that insofar as the first direction of the order dated, what is the order dated? 21/11/2024, passed in WPC 60 of 2023 is concerned, comma, the same was taken up in appeal, comma, which was allowed, and now an SLP is presently pending before the apex court, full stop. Accordingly, compliance of the first direction of this court has been delayed, full stop. The learned counsel appearing for the respondent number, you are appearing for respondent, madam?
1, 2, and 8.
1, 2, and 8 has submitted that they have forwarded the payment as calculated to the Deputy Commissioner, District Siaha, to a check dated. Have you seen the instruction, madam?
The latest one, the latest.
This one you have seen. You have given me a copy, na?
Yes, ma'am.
Please look at the check
Check.
dated.
Dated 12 August.
Oh no,
A date, hold on.
check dated.
Check date is 7/20. It may be mistake, my lord.
7
However,
day
as
of the
per the
20th.
receipt-
Huh?
The receipt, it was written.
A
that
check.
23.
By a check.
My lord, this should be mistake, my lord.
By a check.
Maybe a check number.
Full stop. The Miss Mary L. Kyangte, learned counsel representing the district collector,
Yes.
has submitted that the check has been received and the process for payment of the amount to the petitioners will soon be initiated. She has accordingly prayed that the matter may be taken up after 6 weeks, by which time substantive progress in compliance of the orders of this court would have been completed, full stop. Accordingly, list this matter again on 24th of September 2026. The learned, the respondents by that time shall file a status report in the form of an affidavit. You are appearing for? Ms. Swenso appears for respondent number 7.
Much obliged.
Obliged.
Item number 6.
Right, please, Your Lordship.
Yes, sir.
The learned counsel for the respondent is to bring on record the status of the SLP filed by them.
Your Lordship, I'm here on behalf of my senior SC Kayal. Today, my Lordship, if may allow, I will submit the status of the case at the Supreme Court. Status of the case.
SLP number so and so, not a pending index, earlier court orders. Pending. What are you giving us, sir? What are you giving us this? What is this printout?
Your Lordship, that is the status of the case.
Where is the
yeah.
order?
That case is not listed till date in the Supreme Court.
From May 2026, when you filed it, the order of the court is where? What is the date? 15/11/2023. You file an SLP in 2026 May.
Your
And in August, you are telling us that this is the printout of the diary number. No efforts made by your by the contemners to have the matters listed. There is no stay pending. Yes. Where is their office? Office is where?
Office is in Delhi.
Eh? Delhi.
Yeah. Yes, Lordship.
I think 2.5 hours flight, 3 hours. Huh? Monday? Can they come here on Monday?
Yeah. Yes, Lordship.
Yes, they can
Yeah.
come on Monday. Okay, what is the status report? Just a minute. Mr. Kelly is appearing for whom?
For respondent 1, 2, and 3.
For all the
For all the
Yeah.
respondents.
Yes, Lordship.
You have filed your wakalatnama. Has Mr. KL filed his wakalatnama?
Yes, Lordship.
Your name, sir? Your name?
Lilmangaya.
Have you read the last order?
No.
No. Kindly read the last order. We'll give you 10 minutes time. Read the last order in the case. Have a discussion with the counsel who's instructed you to place before me these two diary number printouts. Okay? And then come back and make your submissions. What should we do today? And you, sir,
Yes, my lord.
you take this one, this printout,
Yes, my lord.
take a copy of this, find out how many objections, when were objections notified, any defects are there in that SLP or not.
Yes, my lord.
Tell us, we will not do that job. You tell us that defects have been detected on so and so dates and have not been cleared.
Yes, my lord.
Give me the printout.
Yes, my lord.
Contemnor should be here before us next week.
Yes, my lord.
Find out, have a talk with your counsel. Go through the last order. We had said that in case you do not place the Supreme Court orders before us, we will decide the contempt on merit. We may draw contempt. Have your instructions. Next.
Item 7.
This will be after some time. Huh? Yes.
Lords,
The written things. Instructions were not. Huh? Where is Miss Lalui? Huh? Respondent number 1235. Who represents?
1 to 5 is state, my lord.
Where is the state council? Yes, why is she shocked?
File 3. Quiero ir a file 3.
Your Lordship, I'm appearing on behalf of the state respondents 1 to 5. I am yet to refile the affidavit of
Ah,
position, Your
because
Lordship.
you, last time you did not have your instructions because they were not legible.
Yes, Your
Have you
Lordship.
sought for fresh instructions?
No, Your Lordship. Actually, this case was handled by Mrs. Calvin. She's on legs in the other courtroom at the moment.
Your name is recorded.
Yes, Your Lordship. But however, for today, Your Lordship, that
What is the matter about?
My lords, we were included in the 3G award,
Huh?
National Highway Acquisition, my lords.
Hmm.
Later on, my lords, the settlement officer, who is not even the competent authority, he decides our title. He says you're not supposed to be in the award. Now, my lords, I'm saying you've become functus officio. Where is the power?
Okay. Let her be here. Let us see if
Yes,
the affidavit.
We have no objection.
Or should we take it up after 2 weeks, allowing them the time to
My
file
lords,
it?
2 weeks, we have no objection.
Ah, okay. Heard Mr. Swansol and the counsel appearing for the petitioner. The okay, CGSC has also not filed. You are not filing any affidavit, madam? Ah. Ms. Swansol appearing for the respondent number 6 has submitted that the Union of India would not be contesting the matter by filing affidavit in opposition. Full stop. However, assistance on points of law would be rendered. Full stop. The respondent number 1, 2, 3 and 5 have not filed their affidavit till date. Full stop. List this matter again on 3rd of September 2026, by which date the respondents may file their response. Full stop.
Deeply obliged.
Item number 8.
May please your lordship, this is a application under 226 of the Constitution against the impunity penalty order dated 6/7/2021, lordship, whereby the petitioner was imposed to pay a fine of rupees 11,79,000 in spite of paying all the taxable side, taxable lordship. So, lordship, the instead case is that it is strictly confined with the section 74 within bracket 1 of this GST Act of 2017 lordship. So here my contention is that until and unless the prima facie case is established against me regarding this fraud, misstatement and suppression of material facts, they cannot charge me because this is a penalty. They must prove that I have that and with the intention that I have to evade taxes. Lordship, there is no intention on the part of the petitioner to evade taxes. We have paid all the tax, lordship, up to date. And in spite of that, this they have imposed me penalty, that is, lordship, under section 74.
The penalty was imposed in the year 2021.
Lordship, that is...
You have come after 5 years.
Yeah, I come after 5 years. This section 74 is not for delay payment. Only when they found my conduct, that is fraud, misstatement and suppression of fact. Lordship, as soon as I have received the first notice, it was introduced only 2017 with effect from September 2017. And the petitioner is a woman and she is not aware about whether the house rent, the income returned from the house rent is taxable items or not. She is not aware. So notice was given to me for the first time, lordship, that is 27/11/2019. I was given, lordship, that is Annexure 2, page 36, lordship.
Annexure
Annexure 2, page 36, lordship.
2. Now they have filed their affidavit in opposition.
Yes, lordship.
Would you like to file a reply or should we fix the matter for being taken up
Yes, lordship.
for hearing? What?
Yes.
Would you like to file a reply?
I have not yet replied, lordship.
Would you like to reply?
Yes,
Do you want to reply?
Yes, lordship.
So,
But, lordship, but I want to bring your kind notice that page 87 and section 83 of the GST Act, lordship, regarding my attachment of This is a bank account, Lordship. This, as per Lordship, this, my bank account was
Attached.
my bank account was attached on 27 to 2025, Lordship. So as per this, as per the section 83 of the GST, Lordship, it is valid only for 1 year, and there is no any provision for extension. The law is silent. So it is already over 1 year, but still they are attaching my. So in this matter, Lordship, if observation can be made that it has no any more validity as per Act. That's my prayer, Lordship. Because it is, the Act is very clear, Lordship, this as per 83, Lordship.
It is, when you approach this court, even by that time the 1 year was over. You filed this petition on 6th of March 2026.
Yes, Lordship.
Order is of 27 to 2026.
Yes,
Why
Lordship.
did you not proceed for on the first day?
Lordship, at the first day, there is an order that
It will be considered on the next day.
interim will be considered on the.
Yes, madam, 1 year validity. Who appears for the tax department?
Your Lordship, the person who appeared is Mr. Johnny, for respondent number 2 and 3.
Ah,
And I believe that, and moreover, we did not receive the reply, the affidavit which he had filed. We didn't receive that. Actually, I'm representing respondent number 4, 5, and 6. That is the pro forma respondent.
so where is Mr. Johnny L. Tochawang? I hope I'm pronouncing it correct. Where is he? Where is Mr. Johnny?
I have
After some time, we'll take it up. After some time, if he does not arrive by then, we'll consider the interim. Okay. He might be in another court, so let us see.
Item number 9.
Affidavit filed?
Yes, Your Lordship, I have filed my affidavit yesterday.
Okay.
I was served the advance copy yesterday. Perhaps it might not be on the report.
It is on record. Now it is up to you. If you want to file a reply, we'll give you some time.
No, my lord.
If you want to
not-
go
not
through
required.
it, we'll allow that. Or if you want to us to take up the matter today, we'll take it up.
Yes, my lord.
All respondents represented.
Yes, Your Lordship.
Your Lordship, if this matter may be taken up next week.
My lord, we have the interim prayer since the beginning, but since this matter pertains to termination of my service, instead of granting the interim order,
We
this court-
decided that it should be done in full.
Yes, my lord.
Did I pass that order?
Yes, my lord. If Your Lordship may kindly see 9/4/2026.
9/4. You had given, you had allowed some people to be regularized. Is it that one?
Yes, my lord. We were appointed as assistant professor on contract basis. And since our initial advertisement, from the initial advertisement, we have been exempted from acquiring various.
I did not have the opportunity to go through this affidavit in opposition.
Tomorrow,
So, tomorrow is Friday, huh? Tomorrow, will you be prepared?
Your Lordship, if possible, next week.
We'll fix it on Tuesday. Tomorrow.
tomorrow if possible, my lord. Because we have been terminated illegally,
They
arbitrarily.
have to here and there.
In their affidavit, my lord, they have no explanation regarding the regularization given to those referred to persons.
They have not given any reply.
No justification. Due to compelling circumstances, they have been regularized by exempting the requirements. That is what they have taken.
Your Lordship, if this matter may be listed on 18, and by that time I will try to rebut all the grounds which you have raised. At this time, I don't have that much time.
You have to
go
reply
through.
the grounds in the affidavit.
Exactly,
madam.
Your Lordship, but however, I have to find my citation as well regarding that, and I have to go through that. And I have pending hearing listed for this
We'll
week.
have it
So
on the
many
18th.
cases were
We'll
there.
have it on the
So I
18th.
cannot consider.
We'll have it on the 18th. will make an observation that on the 18th it will be taken up for disposal.
Let it be, my lord.
Is heard Mr. Swensel and counsel appearing for the petitioner. The respondent number 1 to 5 have filed their affidavit in opposition, and the same is on record. Full stop. The learned counsel have submitted the matter. You would not like to make any reply to this?
If I may be granted liberty, if so advised.
Okay,
if such a-
the learned counsel for the petitioner has expressed urgency since the matter relates to termination of service, and while issuing notice, this court had observed that on the receipt of the response from the respondents, an attempt would be made to take up the matter for disposal on 14/5/2026 itself. Full stop. Place this matter again on 18th of on 18/8/2026, on which day an attempt would be made to conclude the hearing. Stop. The petitioner would be at liberty to file response to the affidavit in opposition, if any, if so advised.
Obliged.
Item number 10 to 13.
Lordship, we have already finished preparing the affidavit. However, Lordship, there has been a change in the process of filing the affidavit by the registry. They implemented a new system. Therefore, we.
What is the
have
new
to-
system?
About the paging. It's about the paging.
No, but see, first 1 or 2 weeks, there might be some difficulty in filing it, but unless we get it paginated as it is done in all the other courts, that will also help us in keeping the papers seriatim, na?
Therefore, Lordship, we have to make some corrections.
We'll have it listed on 25th.
Right.
Huh? Will
Yes,
that do?
Lordship.
25th, only the pagination you have to correct.
Yes, Lordship.
When do
Lordship,
you want
if
it?
possible, can the matter be listed again after a week?
For a week.
Yes.
Today is 13th. 20th? Or 21st? 21st?
Yes, Lordship.
Oh, wait, 21st, on it. 21st, it's all right.
Okay, Lordship. 25th is also.
That is what we had initially proposed.
Yes, Lordship.
At the request of the learned counsel, appearing for the respondent, allowing him time to file the affidavit in opposition, place this matter again on the 25th of August 2026.
Meantime, Your Lordship, there is an interim order.
The interim order passed earlier shall continue in the meantime.
Much obliged.
Item 14.
May it please your lordship. And my lord, we have filed this application for the release of 50% of the compensation amount, which was already deposited into the executing court, fast track court come additional district sessions scholarship, as per the direction of this honorable court, and deposited by the state respondent PWD. And my lord, please may I take you to page number 60, page number 60.
Of the interlocutory application?
Yes, my lord. IA 24. Page number 60. Yes. My lord, please may I read it out this one. Government of Mizoram, Office of the Engineer-in Chief, Public Works Department, dated as well the 10th November 2025, to the Judge Fast Track Court, Mizoram, Scholarship. Subject transfer of fund for work. Please find enclosed here with one number of check bearing number so and so, dated 10/11/2025, amounting to rupees 1,71,12,721 only, for executing of an order passed by the Gauhati High Court to deposit half of the compensation amount as shown below. My lord, here 5 cases are listed. And these 5 cases are connected to each other. And we have this hearing on the item number 3. There, here it's serial number 3. Then the execution case number 3, 2025, arising out of LA case
Where
number
is that
18.
order which required deposit of that 50%?
And this
Where
one
is
is, my lord, page number 54, my lord. Page number 54 is the effective part. Para number 11. Page number 54, my lord. Page number 54, para number 11.
Ah,
Yes. Please may I read it on, my lord.
okay.
Under the given fact.
See, by that order,
Oh, yes, my lord.
by that order, once the party deposits 50%,
Yes.
the execution proceedings are stayed. The moment we allow you to withdraw that money, the execution is carried out. Half the execution is carried out. Will it not be contradictory? I am telling, we give an order saying that if you deposit 50%, execution stayed. Yes? Now that 50% is deposited, what happens? The execution is stayed as a consequence. The moment I allow you to withdraw that money, 50% of the execution is allowed. Where is the stay? The moment I allow you to withdraw the money, the stay goes. Can it happen? Can both survive? The stay of the proceedings and the withdrawal of the money, can they happen at the same time?
But, my lord, this order stay only the attachment order. My
Huh?
lord. Only the attachment order, my lord. The attachment order is 11/9/2025. It does not stay the release of 50%. It only stays the attachment order because
Where is that 11/9/2025?
11/9/2025 is at page number page number 42, my lord. Page number 42. It stay only the attachment order because all the motor vehicles, JCB trucks, and office of the executive engineer office was under attachment. And this order stay not to sell all these things, but all these properties were in a moving and under situation again, my lord. All released, all these properties were already released to the respondent PWD. The office will also run again, my lord. And the motor vehicles were also in a running condition.
Just a minute. Just a minute. Please read that order at page 54. Again.
Para 11, my lord. Para 11, no. Under the given factual and legal metrics and also balancing the equities, this court is inclined to grant stay to the attachment order, dated 11/9/2025.
Though there is
Though
a
there is a prayer for staying the judgment and orders dated 11/9/2025, passed by the learned executing
Now,
court.
just a minute. This is an order of 11. So already the attachment order is stayed
Yes,
at
my lord.
11, at paragraph 11.
Yes, my lord.
Now there is, the next prayer is being considered.
Yes, my
The
lord.
second prayer is being considered. There is a prayer for staying the judgment and order dated 11/9/2025, passed by the learned executing
Court.
court. Now, if you come to page 49, the applicants have prayed for staying the impugned judgment and order dated 11/9/2025 passed by the learned fast track additional district judge within bracket executing court hereinafter. So the judgment and order is also stayed. The attachment is stayed without any condition. Yes?
Yes, my lord.
And the executing court's order of 11/9/2025, the judgment and order, that is also stayed, subject to payment of 50% of the awarded amount. Yes? So the execution is stayed. Yes? If the execution is stayed and I allow you to withdraw the money, have I not allowed the execution to go on?
But, my lord, if it stayed the executing order, my lord, I still have a prayer that
Will it not be better if we take up the RFA? Merits, finish it, take whatever you need to do.
and my lord, I pray that let the RFA be taken up soon. So, Yes, my lord.
You tell us, it is only because of your IA, your insistence on the IA, that we took it up today. On the last occasion, if you had wanted the RFA to be taken up, we would have come prepared with the RFA, we would have finished it today. You have filed your response here? Or would you need some time to do what? Or
No,
should
no,
we
my
take it
lord,
up?
we are ready, my lord. We are ready.
You
The
are
RFA
ready,
also.
yes,
Yes,
madam.
madam.
Who appears in the RFA?
I beg your pardon to your lordship. Unfortunately, I'm not ready today due to
You
the
are not
fact
ready
that
today, yes, he is awaiting for the payment of the awarded amount when?
I'm of the opinion that this
No,
They-
tell
that
us a convenient date, you tell us a convenient date.
after 2 weeks,
He looks very surprised. Huh?
I'm of the opinion that his application will be considered today, but
No, we'll consider the RFA, tell us a date.
yes, after 2 weeks. At the convenience of my learned friend, let him choose a date.
Huh?
Let him
Take a
choose a
date.
date. I'll give him the benefit.
My lord, let that be fixed, my lord.
Huh, tell us a date.
Yes.
Give us a date. Tell us.
Please. 28, my lord. 28 August.
28,
20.
20.
Yes, my lord.
Yes, sir, 20.
28 August is holiday month.
No, 20.
20 August is open. It's
Yes,
after a week.
Well, my lord, let me make one small submission. There is an appeal pending against the original judgment and order from which this execution case is pending. So, may I place the document?
Then what is this?
This is against the execution proceedings.
Hmm.
Now, there is a
See,
appeal.
sir, if you can show this court some merit in challenging the execution proceeding,
Yes, my lord.
we'll set it aside.
Correct.
Or we'll stay it. If we see the execution proceeding is correctly going on, then
There is a challenge to the original award.
by whom? By you?
Yes, my lord.
Huh?
Yes.
So you get your order in that if you lose here.
I'll just
You
place
go and
this
get your order
document.
there.
I'll just place these documents, my lord.
You failed to get an order in that appeal.
No,
You did not get any interim order in that appeal.
I got in some cases. There are many cases connected to that. But the final hearing is yet to be concluded.
No, that's okay. We'll fix it on the 20 August.
Yes, my
My lord.
On 20 August 2026.
I'll produce that.
And then you do what you have to do. You write down in IS civil number 24 2026. Huh? Heard Mr. Swansol and a counsel appearing for the applicants. This is an application praying for release of the amount deposited by the appellants in RFA 49 of 2025 in favor of the applicants. Full stop. After some hearing in the matter, the learned counsel for the applicant has submitted that the disposal of the RFA, of the connected RFA, that the connected RFA may be taken up for disposal instead of adjudicating the present I, full stop, accordingly. List these matters again on 20 August 2026. For consideration of the RFA 49 of 2025. Are there connected matters also along with this? How many matters? RFA 49 of 2025 and other connected matters.
Item 13 to 17.
Your Lordship, there's from 47, RFA 47 to RFA 51.
We will say
51,
like this.
2025.
For consideration of RFA 47 of 2025 along with other connected matters listed today.
Obliged.
Obliged.
Pass over item number 6.
May it please your Lordship, I have inquired from the website of the Supreme Court, and it appears there is some defect.
Which was on what date?
My Lord, I have given a copy, my Lord, starting from page 1, page 5, my Lord.
Where is the counsel appearing?
The defect was notified on 15/5/2026.
Has it been cured?
It has been removed on 12/8/2026, yesterday, last minute.
So we'll have to give them some time.
My Lord. A week time? A week, oh my Lord.
We have now it's August. We'll have it on first week of September.
Yes, my Lord.
August there is already a holiday on 26th and 28th both. On the 3rd of September, yes sir. We'll have the matter listed on 3rd of September.
Yeah. No problem, Your Lordship. No problem, Your Lordship. Yes, my Lord. Yes, my Lord.
Mr. Swenson and Council appearing on behalf of Mr. S.C. KL, Command and Council, and Senior Council, representing the all the respondents. The Learned Council for the appearing for Mr. S.C. KL has submitted that the defects in the filing of the SLP have been removed yesterday, and the matter is expected to be listed soon before the Apex Court. Accordingly, list this matter again on the 3rd of September 2026, allowing the respondents to place before this court the outcome of the under the orders passed in the SLP.
Right, my Lord.
Item number 19.
My lord, if I may please your lordship, this is bail application.
It's come for the first time, no? TCR has come, scan copy.
Yes, my lord, TCR has arrived.
No, the correct one, has it come?
Yes, my lord.
There was some mistake. Now it is the correct one. Okay. Yes, tell us, madam.
Yes, my lord. The accused was arrested on 18/5/2023 at 3 p.m. for alleged involvement in the connection with seizure of 414 grams of suspected heroin, along with co-accused, and he was booked under 21C/21(9) of the NDNPS Act.
Just a minute. You are a second time offender.
No, my lord, this is the first case, and then he was released on bail, and then he was rearrested in another case, since he has already got this case. So on mere suspicion, he was then rearrested. That, my lord, in this case, he was already granted bail by this honorable court. My lord, the bail order is at page 77 of my application.
Page number?
77, my lord. Annexure number 3.
Where is the earlier bail order?
That is the earlier bail order, my lord.
Page 77. Yes. You were released on bail. Then what happened?
My lord, if I may read from para number 10
No, I
at
read it.
page. Oh, my lord.
Huh?
Para
First,
number.
it was rejected because the presumption under section 37 was
Yes, my
against you.
lord.
Then on the next occasion, this court finds that there is a prolonged incarceration, the court is on leave. There are many more witnesses to be called.
Yes, my lord.
6 witnesses were called and 2 of them had not responded to the summons. And therefore, the court felt that you should be granted the bail and you were granted the bail.
Yes, my lord. There are 6 witnesses.
6 more.
Only 2 have deposed before the court, the trial court.
Even
And
now.
yes, even now, till now, the status of the prosecution evidence stood the same. And we had even asked
No, that
before
is
the
all
trial
right. Now
judge.
there is one more factor which is going against you. You are found involved in another crime.
Yes, my lord. That is why bail bond was cancelled.
That is why it was cancelled. Because when this court had earlier given you the bail, you went out and you got yourself involved in the same nature of crime
That, my
again.
lord, that will be, since he's already got this case, then he was framed. He was framed. That, my lord, in the trial also, that we can, in the new case, the second case where he was rearrested, then that, in the trial, it will be established our innocence.
What has happened to the other case?
To the other case that, my lord, bail, we had asked for bail, and there also it was rejected. And the judges said, let them call another witnesses, and then after examination
No.
of another witness, then we will consider the bail.
There are two cases against you, is it not?
Yes, my lord.
So in this case, in the one that is before us, there are 6 witnesses, 2 have been examined.
Yes, my lord.
What is the position in the other case?
The position is at the time of bail hearing, one was already examined, and after the bail hearing last week, another witness has turned up. So
How many witnesses are there?
there are 6 or 7, my lord. Also, my lord, in this case, the witnesses has been called many times. The prosecution.
No, that is not the issue now. We had taken a very considerate view that you should go out on bail because there is a chance of delay in this case.
Yes,
that
my
was taken into account, but then your rearrest is making the problem. You being rearrested in some other case, you being freshly arrested in
That,
some
my
other
lord,
case.
the suspicion was on him. That is why.
Yes, Ms. Kingta, what do you say?
Also, my lord, one more.
Yeah,
There
yes.
is clear violation of Article 22 as well.
Which one?
Article 22, Section 47, 48 of the BNSS, regarding the intimation of arrest, grounds of arrest.
You were arrested, you were granted bail.
Yes, my lord.
The evidence is going on against you. At this stage, at the trial stage, the court felt that you may be allowed to go on bail. Now only
No,
your
my
bail
lord.
has been cancelled. You have not been rearrested.
My lord, bail was granted by this High Court. Honorable.
Yes, and thereafter, when you were arrested again by someone in some
Yes.
other case, the bail was cancelled.
Yes,
The
my
bail
lord.
granted to the bail bonds were cancelled because those
Yes,
people
my
could
lord.
not stop you from going and getting into trouble again.
Yes, my lord. That is exactly what my submission is, that because he became a very prime suspect after having one case. And my lord, he is not even convicted yet, and the trial will prove our innocence. However, the trial is going at a very slow pace. That is why, my lord, we had even asked before the trial court to drop the witnesses. But however, it was
Whose
not
witnesses? Prosecution witnesses, you
Yes.
will ask them to drop them.
Yes,
How
my
will the
lord.
prosecution fight? Huh?
Because, my lord, it has been, there was someone 23 times.
See, like
three times.
like the weapon that is in the hands of the arrested person, 47, 48. That is a weapon, no? To come out
Yes,
on
my
bail.
lord.
So the prosecution also have their own weapons to
My
keep you
lord,
as long as
like if
possible
we
behind
consider
bars.
it, he has been incarcerated for so long, and the trial could not be completed, and then the witnesses have not even turned up. My lord, in between that also there is production as well, cancelling all the production after every 14, 15 days. The prosecution evidences only the PW2 has been summoned 23 times, and the PW3 has been summoned 20 times.
Those were the very reasons why you were granted the bail, madam.
Yes, that is there.
Now he
And
goes
till
out
now,
and he
my lord,
again creates chaos. How can
the status remains the same, even till today. The bail was granted last year, my lord, and till today it's almost 1 year, and the stage of the trial is still the same.
Yes, madam, what do you say?
Your Lordship, with regards to the grounds that my learned friend have taken, 48, 47, now we cannot go into that because it was on that ground that he was released. And with regards to the trial that is going on a slow pace, Your Lordship, that also was the ground taken, and he was released on bail. Now, they are coming here at this stage in the instant application, Your Lordship, as a bail application. Now, they could have filed 227 or criminal petition before this honorable court, challenging their application on dropping the witness, etc. However, nothing of such sort is filed before this honorable court till date. And Your Lordship, I have given a copy of the bail application number 47 of 2026, wherein in the other case, wherein a new case wherein he was arrested, the facts of the case was that they have received information, and he was caught red-handed while he was trying to sell the methamphetamine. And then on his own volition or confession, discovery was made in his residence. So it's not
Again,
that...
in his own residence, the discovery
Yes,
is made.
yes. So, Your Lordship, just to refresh our memory,
That
Your
is in the
Lordship.
charge sheet, my lord. That is not evidence, my lord. That we will rebut in the trial court.
Yes,
Definitely we
but
will.
that is the record that is available as
My
of
lord,
now.
that we are not arguing on that.
She did not
Now, yes.
She did not interrupt you.
Yes, my lord.
So let her
Sorry.
finish. Yes.
Your Lordship, with your permission, Section 37, NDNPS, I wish to refresh our memory, Your Lordship. Just for refresher of our memory, may I read out the embargo of Section 37? This offense to be cognizable and non-bailable in subclause B, subclause 2. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense. And this is what I would like to stress, that he is not likely to commit any offense while on bail. Now, this is a clear case, cut case, wherein even though it is yet to be proved before the learned trial court, but as far as the records that are before us, that we can peruse, Your Lordship, it's he's a habitual offender. So, Your Lordship, considering the menace that the drugs has caused to the society at large, this is not a crime against. This is not a crime against a person personally. This is a crime against the state and a crimes against the public. And in this regard, Your Lordship, at this stage, let the application be rejected. That is my prayer.
Yes, he has to pull his heels for some time.
My lord, if I may reply to the learned PP. My lord, with regard to not submitting any application, my lord, in the TCR at page 189, we had already submitted. It's on record in the
Challenging this.
TCR. We had already submitted before the trial court. And with regard to, my lord, the embargo of section 37, if I may submit one citation. My lord, if I may take your lordship straight to the operative portion at page number 5. If I may read.
Page?
Page 5. Therefore, the second line, my lord. At page 5 on top. Therefore, in our opinion, if a case is made out for grant of suspension of sentence or bail in deserving cases on merits, the court is not powerless to grant relief of suspension of sentence and bail pending an application, even if an accused has not undergone half of the sentence. There cannot be a rule of thumb that a convict cannot be released on bail pending an appeal against conviction unless he has undergone half of substantive sentence. In case, my lord, I'll just skip para number 6. I'll jump to para number 7. At this stage, the learned ASG, appearing for the petitioner, here, my lord, the petitioner is the NCB, Narcotics Control Bureau. At this stage, the learned ASG, appearing for the petitioner, submitted that the power of the court was constrained by Section 37 of the NDNPS Act, which is applicable even at the stage of an appeal. He relies upon a decision of this court in the case of Dadu versus State of Maharashtra. There is no dispute about the fact that the appellate court is bound by constraints of Section 37.
You just come to the last line. Last line of the judgment.
However, if in the facts of the cases, in the case, an accused has undergone a substantial part of the substantive sentence, and considering the pendency of criminal appeals, his appeal is not likely to be heard before the accused undergoes the entire sentence. The appellate court can exercise the power releasing the accused on bail pending the appeal. That, my lord, in our case also, the trial is not moving ahead at all. If the relief of bail is denied in such a factual situation only on the grounds of Section 37 of the NDNPS Act, it will amount to the violation of the rights of the accused under Article 21 of the Constitution of India. Here, my lord, there is clear violation of Article 21 of the Constitution of India in our case as well.
No, madam, we are not convinced that this is a man who should be released on bail.
And also, my lord, if Article 22, if that
See,
thing does
Article
not-
22 is right to liberty and everything. We are all with you on that point. But when having exercised our discretion, this court granted a bail. Now, not only is he found involved, again everything is recovered from his house. Whether that is enough in law to
That, my
convict
lord,
him-
that was also-
whether it is enough in law to go for his conviction or not on the technicalities of it is another part of the thing. Section 37 says, first of all, there must be some amount of presumption that he may be innocent. The second is that he would not be he would not be involved in another offense. Here is a case where you are granted bail in 2025. And in 2026, nearly 1 year later, you are found again involved in the same kind of offense.
My lord, he was out on bail only for 4 months, 4.5 months.
Doesn't appear to be so.
It is
He,
4 months.
when was he granted
18
bail?
days on.
When was he granted bail? Within 4 months he is back to business.
No, my lord, he is
So
not back on business.
he should stay with some free food, some free clothing.
My lord,
and
during
cool
while
his
he was
heel for
out
a
on
time
bail,
being,
also
yes.
he is
Huh?
during on bail also he is out. He has attended court regularly, and then he and my lord, that is the recovery was not from his house.
Huh?
Yes, my lord.
Was your
As per his statement, even though in the charge sheet it was written like that, and there was another two persons involved as well. Those were the source. Those were the source, and they were not even, a case was not even made against him, and he was framed.
No. Somewhere I read it was recovered from your room.
Yes, it was stated like that.
It was also stated by the official that in the presence of witnesses, the house of the petitioner was searched, and the petitioner from his bedroom inside the wooden almirah produced one blue-colored bag. Methamphetamine was found inside, and the same was seized on the same date. Sorry. It's too dangerous to walk around right now.
Yes, my lord, those were the prosecution statement. They could have written whatever they want, and then they could manipulate with the statement of
But
the.
see, if we go by your submission, then calling for the CD and all that, it doesn't matter. Then we can just listen to you and grant a bail or not grant a bail.
Yes, my lord.
Heard Miss L. Fanail and counsel appearing for the petitioner. Also heard Miss Mary L. Khiangtel and APP for the state. Full stop. This present bail application has been preferred by the petitioner under section 483, read with section 37 of the NDPS Act in connection with his custody in SR number 334 of 2023 AO, special narcotic PS case number so and so under section 21C/29 of the NDPS Act at page 2, a pencil mark, full stop. The petitioner was arrested in connection with in connection with the aforesaid case on when was he arrested initially?
18/5,
Huh?
18/5/2023.
18/5/2023, and his application for grant of the privilege of bail by way of bail application number 4 of 2025 was rejected by this court by order dated 14/2/2025. Full stop. The petitioner had thereafter preferred a second bail application bearing BA number 23 of 2025, which came to be allowed on 21/7/2025 by this court. Full stop. This court had noticed that the prolonged incarceration of the petitioner for more than 2 years, comma, where only 2 out of the 6 witnesses had been examined, comma, amounted to violation of his right, violation of his fundamental right under Article 22 or 21 of the Constitution of India. Full stop. This court, in the earlier order granting him bail, had noticed that the fundamental right granted under Article 21 of the Constitution of India would override the statutory embargo created under Section 37 within bracket 1 within bracket small b within bracket Roman small 2 of the NDPS Act. Full stop. The petitioner was thus released on bail on furnishing appropriate sureties before the learned trial court. Full stop. Next paragraph. When were you next arrested, madam?
Pardon me, my
The
lord?
second time, when were you arrested?
6th January 2026.
The petitioner was, however, rearrested on 6th of January 2026 at Aizawl in connection with NDPS case number 25 of 2026 arising out of excise case number N-1/26 registered under section 22 of the NDPS Act 1985. Full stop. You take it from here, huh? The details. It'll be here, huh? Full stop. On his such arrest, where is that order cancelling the earlier bill?
My lord, it's in the TCR. And also in the IA, I think we have submitted before the registry, before listing, laying before the bench. Might be in the correspondence file. On the arrest of the petitioner in connection with NDPS case number 25 of 2026, his earlier bail bonds stood cancelled. This is the cancellation order.
Bail bonds stood cancelled. Yes, give us a full stop. Just a minute, don't write, huh? His bail bonds were cancelled and the sureties were discharged from the liability of surety by the order dated 19/4/2026. This is a mistake or what? This 19.4?
Yes, my lord, it's a mistake.
It should be
It should be
2026. 19.4 2026 full stop. Next paragraph. The learned counsel appearing for the petitioner in this bill petition has submitted that the situation regarding the trial in Special Narcotic PS case number N/33 of 23 has remained the same, and only two of the witnesses cited by the prosecution have been examined as of date. Full stop. She has accordingly prayed that the petitioner is required to be granted the privilege of bail again by this court. Full stop. I have produced the trial court, scan copy of the trial court records, and it is seen that only two of the witnesses have till now been examined, while other witnesses, despite summons being issued, have not appeared before the court. Full stop. Miss.
My lord, if my submission on Article 22 may be also reflected.
Of 47 and 48.
Yes, my lord.
Which one?
At para,
Which 47, 48? Tell us.
at para
No.
11.
47, 48 at what stage?
My lord,
At what stage, madam?
now the stage is prosecution evidence.
Violation of 47, 48 at which stage? Violation of
At the
47
time of
and
arrest.
arrest when?
Arrest, that was in 2023, my lord.
23. So 2023, the police arrested you.
Yes, my lord.
Yes. So if there was any violation of 47, 48, all that arrest is bad. It is gone. Now you are arrested because now your bail bonds are cancelled. You are not being arrested.
Yes,
Your
my lord.
bail bonds are cancelled because they are not being able to stop you from
But
doing
we
things
have-
you are not
my lord,
supposed to do.
we have not taken this stance. However, if you're going to reject anyway, so if it may be reflected in the order.
The learned counsel for the petitioner
I've
has
already-
submitted
Yes.
that the initial arrest of the petitioner in the year 2023 is also vitiated in law, since the notices under section 47 and 48 of the BNSS the provisions of sections 47 and 48 of the BNSS had not been complied with at that stage. Full stop. Miss Marie L. Kyanti has submitted that, APP has submitted that the petitioner had been granted the privilege of bail by this court, and only about 4.5 months later, commercial quantity. It is commercial quantity, yes. Commercial quantity of what? What was recovered? Commercial quantity of dash was recovered from the residence of the petitioner at his instance. Full stop. The learned counsel has submitted, the learned APP has submitted that even though the petitioner was granted the privilege of bail, it is apparent that he has misused the same, and the sureties were not able to discharge their duties of restraining the petitioner from committing offences while being on bail. Full stop. The learned counsel, the learned APP has submitted that since both the cases involve commercial quantity of contrabands, the provisions, the twin conditions contained in section 37 of the NDPS Act have to be satisfied before this court would consider the grant of privilege of bail to the petitioner herein. Full stop. We find force in the submission of the learned APP that in the present case, there are not enough reasonable grounds to believe that the petitioner is not guilty, and with his arrest in the second case, this court is not convinced that the petitioner would not be involved in criminal offenses if allowed the privilege of bail. Full stop. Insofar as the argument of the counsel for the petitioner regarding the shortcomings in the notices under section 47 and 48 of the BNSS is concerned, this court notices that the that in the present case the bail bonds of the petitioner have been cancelled while at a time when he was arrested in connection with other similar offense, and therefore in the view of this court, any shortcomings in the notices under section 47 and 48 at the time of the arrest of the petitioner in the year 2023 has lost all importance at a stage when the petitioner is now facing trial in is facing two trials in offenses of similar nature. Full stop. It is also seen that in the earlier round of litigation, when bail was granted to the petitioner, there was no reference, there was no submission made regarding the shortcomings in the notices under section 47 and 48 of the BNSS. Full stop. Having gone through the materials on record and for the reasons recorded herein above, we are not inclined, I am not inclined to grant the privilege of bail to the petitioner in connection with SR number so and so, along with special narcotics PS case number so and so. Full stop. At this stage, full stop. A copy of the orders passed in bail application number 57 of 2026 on 22/7/2026 is kept on record, marked as annexure, marked as X. Bail petition accordingly dismissed.
Okay.
Yes.
Pass over item number 8.
This section 87 of this GST Act is very clear, Lordship, that its validity is only for 1 year. It is already expired.
Yes, Lordship. I'm appearing on behalf of my senior, Mr. Johnny, standing counsel for CGST, Lordship. And my lord, we did not have knowledge about the updated cost list. So my senior is not here.
List?
Yes, Lordship. Last night we
Is
have
it
checked
updated
the
cost
cost
list?
list.
Updated. Why updated?
So, Lordship, if this matter may be passed over for a day, my lord.
We'll have it tomorrow, sir.
Lordship, this matter, it is very clear. Last time also, three chances given for this interim order, Lordship. So, Lordship, it is only just to make this,
because
he is in the district court. He should have
I
been
know,
come here.
since it is an updated cause list, let us not put aspirations on the consuls appearing. So, since it is an updated cause list and they did not have notice of it, we'll put them to notice and take it up tomorrow.
All right.
Today or tomorrow will not make much of a difference. Tomorrow you are here?
Yes, Lordship.
You are available? Tomorrow. At the request of the counsel appearing for the respondent, list the matter tomorrow, full stop. It is made clear that the interim prayer made by the petitioner shall be considered tomorrow.
Obliged, Lordship.
Item 23.
20.
May it please your lordship. Lordship, I'm
May
appearing
it
on
please your
behalf of
lordship.
senior counsel and special PP for the respondent number 2, Mr. Sizoram Chana, who cannot appear today due to some medical reason. So, lordship, may this matter be taken up on next Tuesday, 18th of August.
He had suffered some accident.
Yeah, and he has been discharged from the hospital.
On
He's
earlier
he has
occasion
been
also,
discharged.
they took time.
So by
here-
next week, he'll be
Just a
able
minute.
to attend the court again if possible. So,
Huh, Mr. Ahmed, he has been released from hospital and he would like to attend on Tuesday.
Here, Lordship,
Yes?
Lordship, only my prayer before Lordship is that Lordship, they have, I am paying for bail on the ground that 48 is violated.
I understand.
Because 48 notice was
If we keep it for
not
the
given to them, the accused relative of the person. And they have filed their affidavit, Lordship. They have filed their affidavit. I am not going beyond their affidavit, Lordship. Paragraph 17, Lordship, may kindly see, they admitted that intimation was given to them and intimation and grounds of arrest are two different things. Husband is also there. So on that admitted fact, I'm on interim. I'm paying for interim, Lordship.
No, but since the standing counsel is today not in a position to attend and he has assured that he would be attending on Tuesday, being released from hospital in the extraordinary circumstances, I think we can have it on Tuesday.
That I leave up to your Lordship, but Bihan Kumar says if it is found that constitutional rights are violated, he cannot be kept in custody for a second. That paragraph 19, last line. So I am not paying anything, also disputed facts I am not placing. Only the affidavit they have filed, that paragraph 70. And only interim they can argue on that. When
Yes,
they
in
appear
what
also.
manner have you done it, madam? You are saying in your affidavit that, do you have your records?
no, I'm not having it with me.
Huh?
It's all with him at home.
No, since
my
you are
lord.
saying that it is, section 48 has been complied with. Where are
They
your
have given the intimation, and that is at page 60. Your Lordship will find
Mr.
that regarding
Mr.
only arrest.
Mr. Ahmed, we will not go by the words written on an affidavit by someone to say whether it was an intimation or it was a proper
Yes,
intimation.
yes, Lordship. Lordship may kindly see that.
So at the best, we will only ask for them to have the records before us.
No, in last part of their affidavit also, your Lordship will find. So in last part of paragraph 17 also, your Lordship will find they have admitted that they have informed the grounds to the accused, and they have used the word intimation to the relatives.
Then how come the court records that there has been compliance?
Because that intimation was given, Lordship. Intimation of arrest.
Where is that order of the trial court? Where is the order of the trial court? Is it there?
It starts from page 51. And relevant portion your Lordship will find paragraph 4, page 55.
Paragraph?
Paragraph, Lordship, just I'm placing. Paragraph 5, Lordship.
Where are those intimation? Have you annexed the copies of the intimation?
That your Lordship will find page 60.
60.
Yes, Lordship.
No, that is, brother, where is the wife? Intimation to wife.
That is the intimation, Lordship, intimation of arrest.
What is page 61?
That is the notice, it was never served.
Huh?
That is the notice under section 48, they have enclosed with the charge sheet, but this was never served to the relatives. Your Lordship will not find signature of any relatives, Lordship.
And if a written communication is sent to the wife, if she has received a written communication of this, if she has received the PDF of this, then how would it contain the signature of anybody?
No, they have said, Lordship, intimation of arrest. So,
No.
intimation
There is no intimation in your petition
arrest
marked
is
to
at
the
page
wife, sir.
60.
There is no intimation marked to the wife in your petition, sir. There is only this intimation of arrest regarding. Yes. This says it is informed to you that in connection with NCB Agartala, this much of heroin, this much of this, by the special narcotics, your husband was found, arrested, he was arrested, and he is being produced today, and therefore after he will be produced before the Honorable Special NDPS Court. What more information do you need?
Their affidavit also, just one line I am reading from their affidavit.
Their affidavit we
Further,
understand. Their affidavit.
intimation of arrest addressed to Nuri Jahan. So, only intimation of arrest. Yes. Paragraph 17, Lordship.
Yes,
page
where is the
14,
records?
Lordship, may I kindly see.
Where are the records?
Paragraph
You are saying you have given everything to the petitioner. Where are the records showing that this was sent
my
from
lord,
this
I
number,
do not
that
have
number?
the file with me. Actually,
Okay.
it's all with my senior at his home. So
Yes, we'll
the
give you time
instruction-
till Tuesday.
Yes, my lord.
Produce it on Tuesday.
Yes, my lord.
Produce all records.
Yes, my lord.
Heard Mr. A. Ahmed, learned counsel, appearing for the petitioner. Mr. Ahmed has submitted that the respondents had failed to adhere to the conditions mandated for section 47 and section 48 of the BNSS while arresting the petitioner, full stop. He has submitted that only an intimation of arrest had been sent to the wife of the petitioner number. How many petitioners? One.
One petitioner.
Wife of the petitioner. And the grounds of arrest had not been furnished, full stop. He has also referred to the affidavit in opposition. Not affidavit in opposition, to the objections to the bail petition filed on behalf of the respondent authorities, and has submitted that even the same only reflects that an intimation of arrest had been forwarded to whom? The cousin brother or who?
of the accused.
Huh?
Cousin brother of the accused.
To the cousin brother, to his cousin and brother-in-law
brother-
on different phone numbers, and that the intimation of arrest addressed to the wife,
Right.
intimation of arrest addressed to the wife had also been sent via WhatsApp, which was duly delivered to his wife, and the screenshot of the same had been placed on record with the supplementary complaint, full stop. The learned counsel has submitted that submission of intimation of arrest would not suffice the conditions under section 48 of the BNSS, and therefore the petitioner is entitled to bail, full stop. It has been submitted on behalf of the NCB that behalf of the respondents that the learned senior counsel the learned senior counsel appearing for the respondents has been recently released from hospitalization and would be in a position to appear before this court on 18th of August,
18th August.
along with the relevant records. Full stop. This, Mr. A. Ahmed learned counsel has submitted that in the event the arrest of a accused is found to be in violation of the law, he should not be detained in custody even for a second, full stop. In the given facts and circumstances, comma, to determine whether the notices served upon the notices under section 48 of the BNSS had been actually served upon the wife of the petitioner in the manner and form sought to be projected by the respondent authorities, this court deems it appropriate that the respondents produce the records, full stop. Accordingly, list this matter again on the 18th of August 2026 along with the records maintained by the respondent authorities, full stop. The court takes notice of the stand that the respondent stand of the respondent authorities that the learned trial court had already recorded, comma, after perusal of records, that the notices under section 48 of the BNSS had been effectually served upon the wife of the petitioner, full stop. List again on 18/8/2026 for further consideration.
Obliged.
Yes, next.
Item 21.
Your Lordship, this is also a bail application, and on the last occasion, the trial court records were called, and as per the office note, it has not come.
It is
So
not
if a reminder may be sent to the registry, madam.
Huh? The trial court record has come. What is your ground?
My main ground is that, my lords, the petitioner herein was arrested on 7/4/2025, and he was charged under 21B of the NDMPS intermediate quantity.
21B.
21B, my lord, yes. So, in the co-accused has already been released on bail, on the mainly on the ground that the judicial custody of the judicial detention is no more required. And now, as per my information, my lords, the prosecution evidence has concluded. And it is at the time of filing this bail application, the case was at the stage of 313 CRPC for examination of the accused. So I have annexed the,
So one of your grounds that it will take it is a prolonged
my lord,
process goes.
my lord. So the
He's already in 313.
his detention is no more required, my lord. There is no chance of hampering the evidence, my lord.
But at this stage, if you hearing the trial,
I don't know whether the 313 has been completed or not, my lord. But
where is that 48 notice, madam?
that is also one of my grounds, my lord. The 48 notice is not there.
I'm going through the reports as of now. I haven't gone through completely.
We'll have it tomorrow. Tomorrow?
My lord.
Let her go through the records.
My lord.
Okay, the trial court records have been received. Full stop. List this matter again tomorrow, allowing the learned APP to go through the trial court records. Yes.
Your Lordship, I would like to seek your indulgence. Your Lordship, we have duly received, however, till it should be till page 33, the order sheet, because the order sheet that I can see is till 15/12/2025 only. And in the content, it's written page 1 to 33. However, this contains only page 13. So another 13 pages, 10 pages, sorry.
That is all right. If you can find out the
No,
this thing?
that is, without that, I cannot find out the stage of the trial.
the stage of the trial, it is in his interest to have a certified copy of the stage.
I've checked it from the e-court records, my lord, through the website. And at the time of filing, it's pending at the stage of 313.
313.
Yes, but now it may have been concluded, and maybe in the defense evidence.
If
my
that,
maybe in the defense evidence already, my lord.
we'll take it that it is in the stage of 313.
My lord.
And if you have any objection on the length of detention already undergone, number one, number two, the requirement of him being kept behind bars when the allegation is under 21B, and further that one of his colleague, one of his co-accused, not a
Co-accused.
colleague, na?
Yes.
We can't say colleague, we should say co-accused. One of his co-accused is already released on bail. So, whether we need to detain him any further?
Your Lordship, there is no section 48
Intimation
intimation
there, na?
copy. However, 47 is there
Ah,
without.
47 is there. 47 he has annexed.
Yes.
47
47
also
notice he
maybe.
has annexed.
48 is not there in the records.
From where do you belong? Here only.
Yes, from Kolasit.
Where is your co-accused bail order?
Co-accused bail order it starts from page 18, my lord.
1-8.
1-8, annexure 5. Relevant portion is starts from page 24, para 14 and 15. Co-accused was released in January this year. Now we are already in August, my lord. So
Yes, madam. Should we dispose it off now?
Yes, Your Lordship.
Heard Mr. Swenson, counsel appearing for the petitioner. Also heard Miss Mariel Kyanti, learned counsel, learned APP. Full stop. This is an application under section 483 of the BNSS for grant of bail to the petitioner in connection with SC within bracket K number 13 of 2025 A/O X KL. You take it down from here, huh? I'm marking it by pencil. The first page, huh? Under section so and so. The petitioner was arrested on
7/4/2025.
7/4/2025 and has been in custody ever since. Full stop. The learned counsel for the petitioner has submitted that the trial of the petitioner and the trial has proceeded and is at the stage and according to his last instructions, it was at the stage of recording the statement of the accused under section 313 of the CRPC. Full stop. The learned counsel for the petitioner has submitted that at this stage there can be no question of the petitioner hampering or tampering with the prosecution case or evidence in any manner whatsoever. Full stop. The learned counsel for the petitioner has also submitted that a co-accused in the matter, who was also facing trial, had been granted bail by this court in bail application number 58 of 2025 by order dated 27/1/2026, recording that the length by taking into account the length of incarceration suffered by the co-accused. Full stop. The learned counsel for the petitioner has submitted that the petitioner has undergone a longer period than his co-accused, and therefore this court may consider the grant of privilege of bail to the petitioner. Full stop. The learned counsel has further submitted that even otherwise notices under section 48 of the BNSS 2023 had not been served upon any family, friend or relative of the petitioner at the time of his arrest, and in even such view of the matter, the arrest of the petitioner and the continued custody would become illegal and the petitioner would be entitled to be considered for grant of bail. Full stop. The learned APP, Ms. Kyanti, has submitted that the trial of the petitioner has proceeded at good pace, and now at the fag end of the trial, there would be no requirement to consider the case of the petitioner for grant of bail. Full stop. She has further submitted that the trial court records have not arrived in full, since only orders up to 15/3/2025 are available and the rest of the orders are not available. Full stop. I have gone through the trial court records available, and I have also considered the submissions made by on behalf of the petitioner and the objections raised by the learned APB, full stop. Considering the period of incarceration already undergone by the petitioner and also the fact that the prosecution witnesses have now been, the prosecution evidence is over, comma, I do not consider it necessary for further custodial detention of the petitioner in the event strict conditions are imposed to ensure his further participation in the trial. Full stop. Accordingly, it is provided that on furnishing a bail bond of rupees 50,000 with 2 sureties of the like amount, comma, one of such sureties being a government servant, comma, to the satisfaction of the learned fast track court, Kolasip, district Kolasip, Mizoram, comma, the petitioner shall be allowed the privilege of bail subject to the following conditions. Take from page 25, huh? Good stuff. Bail application accordingly disposed of.
I'm deeply obliged.
Item 22.
Let's see. This is also a bail application, which is filed under section 482 of the BNSS, which is being filed under section 482 of the BNSS, read with section 37 of the NDNPS Act, my lords. Well, lords, the brief facts of the case is that on 16th of June 2026, Inspector Zothan Fluangitchen Shang from Excise and Narcotics, and based on her information received and after taken down into writing, seized 350 grams, that is 30 soap cases of suspected heroin was seized from the vehicle driven by the accused number 1, Mr. Zava, from his truck. And then the accused number 2 and 3, which was the suspected to receiver, were also arrested at that night on 16th of 6. And then, my lords, based on the co-accused statement, so out of 30 soap cases, 20 soap cases was sent by me from Champai, and another 10 soap cases was sent by the other person. So that is the allegation against me, based on the co-accused statement.
No, you are the recipient.
No, my lords. So
who are you?
Based on the driver, I was the sender of 20 soap cases.
Okay.
So then, my lords, on 17th of June 2026 at 7:15 a.m., I was arrested at Champai. So then the seizure and first arrest was made at Aizawl. And then based on the co-accused accused statement, I was arrested at Champai. And then I was sent to Aizawl. And now I am being kept in custody at Central Women's Jail, my lords.
Yes, madam. Anything?
My lords,
Okay.
my lords,
Yes.
I have two submissions. My first ground is based on the co-accused statement. And my lords, one of my submission is that, my lords, 42 violations, section 42 of the NDNPS Act violation, which is a mandatory. So, my lords, the information was received by Inspector Zothan Kluangi Chen Trang, which is at page number 9. So, as per the information, Mr. Zawa, driver of MZ01 AB 9551, was transporting heroin, and he recorded that information. And then he made seizure and arrest. 3 persons were arrested on the very same night. And then, my lords, after during interrogation, the other co-accused stated that I was the sender of 20 soap cases. And then before I was arrested, no information has been reduced into writing, my lords, by the arresting officer. The arresting officer is other person.
All these would be good grounds for trial.
My lords,
Tell us about the bail. The recovery is of a commercial quantity. 37 comes into play.
my lords, nothing was recovered from my possession.
Okay.
Even my mobile phone was not seized. Even my mobile phone was not seized. And the Honorable Apex Court also said that 42 violation is to be considered in the bail application, and even a coordinate bench of this court also granted bail due to violation of this 42 violation, my lords.
Okay.
My lords, I have compiled, I have prepared a compilation of judgment, my lords,
Okay.
in this regard, my lords. My lords, I don't know whether it is a prescribed format or a formal one, or because I have never seen once, so I have prepared it with my own idea, my lords.
No, what did you say? We could not understand. What did you say?
My lords, this compilation of judgment, my
Huh.
lords. My lords, the first one, the first citation is Karnal Singh versus State of Haryana. My lords, it starts from page number 1 to 18. And the relevant para is at page 17, my lords.
Okay.
Page 17, para 17.
No, but that it is wrong is very well. To 42 should be complied with. And delayed compliance will also work. That is one part. Tell us the ground of bail that if 42 is not complied with, we can consider your bill.
And well,
Tell us that if 42 is not.
my lords, here the information was received by Inspector Zhou Tantluangi, and she reduced it into writing. And then after that, from the statement of the co-accused, another information was received regarding my involvement. So that has to be taken down into writing, my lords. That I was arrested by another officer, my lords. Silal Dinpuyi, another officer, my lords. So investigation was also carried out by another officer, my lords. So, my lords, my next citation is that the Honorable Apex Court judgment, Sari Jaban alias Janarthani
I have
alias,
seen that.
which is at, starts from page 19, my lords. And the relevant para is at page,
Para 7, page 21.
yes, my lords.
Yes.
So, here this Honorable Apex Court said that 42
I
has to
think
be considered well or
I
well.
think you have made your point. Yes, madam?
My lord, as per the submission and as per the records, my lord, you'll see that at page 12, grounds of belief has been recorded by the IO, the officer in charge, OC. This is dated 16 June 2026. And there is nothing wrong with this, my lord, because they have reasons to believe that one vehicle is used for keeping or transporting some quantity of illicit
Which,
drugs.
what page did you say?
Page 12 is the grounds of belief.
Huh?
My lord, grounds of belief is already recorded.
A ground of belief recorded. What he says is, the seizure is made. You stop the truck, you recover whatever you have to, you arrest 3 persons.
Yes.
Now, before arresting this lady, that there is a information against her.
There is no information, my lord. Only she is arrested on the basis of this grounds of belief. My lord, nothing was recovered from her.
When was she arrested?
She was arrested
17.
on the next day. my lord.
17,
Next
6.
day. Your lordship may turn to page 25A.
Yes, what do you say about page 12?
Yes, my lords. Yes, page 12. So that the vehicle, as per the NDNPS Act, my lords, 42, after sunset and before sunrise, after sunset and before sunrise. So the seizing and arresting officer, before conducting a place, he has record his ground of belief, apart from the information recorded, my lords. So this ground of belief was recorded before conducting search and seizure and arrest of the vehicle, my lords. So I was arrested later. So this grounds of belief was recorded by Inspector Zhou Tantluangi. So I was arrested by C. Laldin Pui, the other officer.
No, we are just asking him so that you can keep on clarifying. Yes.
Yes, my lord. On the basis of this grounds of belief, my lord, some persons were arrested, 3 persons. And on the basis of the statement, we found that the involvement of the present applicant. And on that basis, my lord, we have arrested the present applicant at page 40A. This is the grounds of arrest. No separate, my lord, grounds of belief have to be recorded because nothing was seized from her possession. It was only found out that she has involvement in this case, in the particular case. It's an ongoing investigation. And on the basis of the grounds of belief, we have arrested the present applicant. And we have complied with all the provisions, my lord, section 47 and 48 also. There is no violations of any provisions of NDPS. my lord.
So that is your only ground, section 42.
42 and my lords, only based on the co-accused statement, that the citation that my lords from 4 to, I have quoted 6, I have referred 6 judgment, my lords. From 4 to 6 were released due to co-accused statement, my lords.
What is this number 5?
5, my lords, this is a coordinate bench of this court judgment. My lords, the relevant para starts from page 58, from para 20, my lords. Oh, page 58, yes, para 20, my lords. A coordinate bench of this court judgment.
ठीक है. Yes, madam.
From para 20 onwards, my lords.
Yes.
And now, my lords, regarding section 42 also, point number 3, Lalbiakima versus State of Mizoram. This is also a coordinate bench of this court judgment, my lords. 42 violation.
Okay. Yes, madam.
Yes, my lord. As per section 42 of NDPS, my lord, the proviso, it has, may I read out, my lord?
Yes.
Provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance, or enclosed place at any time between sunset and sunrise after recording the grounds of his belief. So, my lord, the grounds of belief was already recorded, and now they are arresting the persons. So, the separate is not required.
My lords, in that regard, my lords, at page 28, from para 11 onwards, a coordinate from page 28, from para 11 onwards, my lords, a coordinate bench of this court had clearly dealt with it.
Okay.
Whether the grounds of belief or the information recorded earlier can save another one, my lords.
Okay. We'll consider it, we'll pass orders in the chamber. Disposed. Give it to me.
Deeply obliged.
Anyone for hearing matter?
5, your lordship would recall that
What happened to item 5? Why was it not called?
that's usually we wait for the
Huh?
daily cause this part 1 to finish.
Oh, this is part 2.
Yes.
Yes, someone was required to give us that written
Yes.
thing only. Yes, madam. Prepared?
Yes, sir.
When did he expire this?
My lords,
Employee?
22nd June 2016.
Till such time, no recovery was made or part recovery was made.
My lords, I'm sorry.
Till the time of his death, was any recovery made?
My lord's recovery was made from his pay.
Salary.
Salary.
So there was some recovery made, na?
Yes.
This judgment is given by Madam. Is there any difference between pension and family pension?
Yes.
This judgment is of pension. Huh? It's of pension, not of family pension. Okay.
We just provided a small written submission.
I've seen.
Can I just say one thing, my lords? Just so that, my lords, subject to outcome, and my lords, the apprehension that, and my lords, we want that the litigation stop here. My lords, in the counter affidavit of the state, they have stated in para 6, my lords. If this could be, my lords, reflected, my lords, in para 6 of the counter affidavit, the state says that to whom are the nominees of the different retirable benefits. If the same could flow in that manner, so that nobody, my lords, fights again. Para 6.
In case there is a pension order, it will be only in favor of the eldest surviving wife.
Yes. Yes.
And the rest of the persons should be dependent on.
My lords, the other retirable benefits may flow as per para 6. And my lords, the family pension, my lords, we've placed on through an affidavit the agreement between the my lords, petitioner number 6 and respondent number 7, who is the eldest surviving wife. My lords, we have said that we are agreeable to a.
You have given that affidavit
Yes, my lords.
to the court.
Yes, yes.
Okay.
That may be, my lords, kindly.
Mr. So appears for the petition. Give all the attendance. So appears for the list of the respondents. Hearing concluded, judgment reserved.
Just one ruling I would like to submit for
Please.
the case of justice. This one I have already made the petition. State of Jharkhand and others versus Jitendra Vipar Srivastava. Reported in 2013, volume 12, SCC, page 210. Para 8, 14, and 16. Lordship knows this particular judgment very well. During the hearing in the early days, also mentioned this particular judgment. That's why I submitted. I don't need to read the relevant paragraph. Paragraph 8, 14, and 16. Those are related. The same may be reflected. I'm appearing for respondent number 7.
7 years.
Wherefore this is governing 7.
The only difference is today morning we had the occasion to understand that not only in the service law part, even in PILs, family pension and pension are given to very different status. was something new to us.
My lords, the rules in the pension rules itself, also the definition is, my lords,
Totally different. Keep this along with the. Huh? Anything more, guys? Any more items? Yes. We have 5 minutes to go.
Your Worship, item 4 is also there, my lords. Fixed for today. It's an appeal against acquittal, my lord. The informant has filed this appeal, my lord. But it may take some time, my lord. So it can be taken up on the 20th next week, my lord.
This is from the hearing list, is it?
Yes, my lord. It's a criminal appeal, my lord.
Part 2 list?
Part 2. Criminal appeal 42 of 2023. It may take
List this
some
matter
time.
again on the next week.
20 if possible, my lord.
No,
20th.
list this matter again on the 20th of August 2026
Oblige.
for hearing.
Item 6.
Since there's paucity of time, item number 6 and 8 may be taken up next week. Worship permits.
Taken up on when?
Next week,
Next week. Any fixed date you want?
not particular.
List this matter again next week.
Item 7.
All represented. Informant is represented. Okay. You want to do it today?
Permits, my lord.
Huh?
If time permits.
Yes.
My lord,
Yes, Your Lordship, this is a part heard matter.
part heard matter.
Oh, this is a part heard matter.
Yes.
It was heard last week.
Okay. I forgot. I part heard and part forgot. Huh? What was the matter? This.
My lord, the matter was that
And why did we keep it part heard? What was the allegation? My elder sibling's daughter. Yes, my elder sibling's daughter, huh? Okay, it is the stepfather. Then what happened? Why did we not finish it that day? Where were we? Here see mother and accused as liquor. Accused mother victim. Statement of the victim, where is it?
statement of the victim.
Huh?
26 to 27. My lord, on going through the details of the evidences, my lord, I find that there are some inconsistency in their narration of the